A brief history of the case of Texas v. Lawrence. On September 17, 1998, police officers in Houston responded to a reported weapons disturbance at the apartment of John Lawrence. A complaint came from a neighbor who told the police there was a man with a gun going crazy. Police entered the unlocked apartments with gun draws. Lack of warrant did not come up or was not punishable. Police found Lawrence engaging in consensual sex with though according to Lawrence, the two did not engage in any sexual activity. Four officers in the apartment, two failed to note any sexual encounter, while the other two gave conflicting accounts, one vaguely recalling oral sex, and Quinn alone claiming to have seen anal sex. From numerous interviews, is that Quinn had a well-earned reputation for turning minor disturbances into major confrontations. They were tried, found guilty, and fined $200 each. The neighbor later admitted that he had been lying, pleaded no contest to the charges of filing a false police report, and served 15 days in jail. The primary legal issues of the case. Charged them under a Texas criminal statute that forbade deviant sexual intercourse between people of the same sex. The Texas statute making it a crime for two persons of the same sex to engage in certain intimate sexual conducts violates the Due Process Clause. Amendments and laws applied. Lambda Legal Defense and Education Fund took on Lawrence's case, appealed Texas court systems on the ground that it violated the Equal Protection Clause of the 14th Amendment, which prohibited the state from denying to any person within its jurisdiction the equal protection of the laws, and a similar clause of the Texas state constitution. Plaintiffs lost at each stage. The court relied on Bowers v. Hardwick. Bowers v. Hardwick was legal regarding sodomy, sexual intercourse involving anal or oral sex laws between homosexual individuals. The Supreme Court in 1986 upheld a 5-4 Georgia state banning sodomy. Lambda believed that after the Supreme Court's favorable opinion in Romer v. Evans, 1996, which voided an amendment to the Colorado Constitution prohibiting laws bearing discrimination against gays, there would be a good chance that Bowers would be overturned. Lambda then appealed to the U.S. Supreme Court, which they accepted on December 2nd and heard oral arguments on March 26, 2003.
The court was presented with three questions. The first one was whether petitioner criminal convictions under the Texas homosexual conduct law, which criminalizes sexual intimacy by same-sex couples but not identical behavior by different sex couples, violate the 14th Amendment guarantee of equal protection of the laws. The second question was whether petitioners' criminal convictions for adult consensual sexual intimacy in their home violate their vital interest in liberty and privacy protected by the Due Process Clause of the 14th Amendment. And the third question was whether Bowers v. Hardwick should be overruled. In a majority opinion, the court answered no, yes, and yes. In a 6-3 opinion by Justice Anthony M. Kennedy, he held that the Texas statute making it a crime for two persons of the same sex to engage in certain intimate sexual conduct violates the Due Process Clause. The court explained that the right to liberty under the Due Process Clause gives them the full right to engage in their conduct without the intervention of the government. Justice Kennedy continued that the Texas statute furthers no legitimate state interest which can justify its intrusion into the personal and private life of the individual. Ultimately, the Texas law was struck down, and John Paul Stevens, Anthony Kennedy, David Souter, Ruth Bader Ginsburg, and Stephen Breyer voted that not only should the Texas law be struck down, but Bowers should be overruled as well. Sandra Day O'Connor agreed with the first statement, but not the second, while William Rehnquist, with Justice Scalia and Thomas, upheld the law. And Justice Scalia's dissenting opinion, he said that state laws against bigamy, same-sex marriage, adult incest, prostitution, masturbation, adultery, fornication, bestiality, and obscenity, every single one of these laws is called into question by today's decision. To summarize, Justice Scalia warned that if the court was willing to strike down sodomy laws, then other state laws on moral choices could soon be lifted like gay marriage. This decision, though, created widespread backlash. Within a year, 12 states had created amendments that limited marriage to one woman and one man. In 8 of these states, the amendments also barred civil unions. A civil union is a legal relationship between two people that provides legal protections to the couple only at the state level. Back then, this was used to support gay couples and all other same-sex partnerships. By 2006, 29 states had blocked legal recognition of same-sex marriage. But around this time, public opinion started to shift. There was an increasing number of gay individuals who made their sexual orientation public, which led to an increasing number of heterosexual individuals who knew gay persons as loved ones, friends, and regular people. Public attitudes began to change, and more people favored the recognition of same-sex marriage. Public attitudes accompanied changes in state laws, and more states began to create civil unions.